ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్, 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్.
Mom, what did the man mean when he said, go back to where you came from?
Go back, wherever you're from.
Why do they make fun of my name at school? Dad, who will protect us from climate change?
Global warming, and a lot of it's a hoax. It's a hoax.
Why is Mommy coming back from hospital?
Our family's future is at stake. The choice is ours. Vote Asaf and Warnock.
I'm a lifelong Republican and I'm pro-business.
I'm a Georgian and I believe in personal responsibility.
I'm a Georgian and I rely on my Social Security and Medicare.
I am a mother and I believe in immigration policies that support family unity.
My party is not fiscally responsible anymore.
It's irresponsibility that's costing us our lives.
It threatens my Social Security and Medicare.
It is keeping our families apart.
That's why
I am
voting
Asaf
and
and
Warnock.
Warnock.
ఎక్స్చేంజ్.
Hello viewers, here we are with your much awaited program on TVASIA Telugu. మనతో ఉన్నారు immigration specialist, founder of Reddy Neumann law firm, మన talk show expert and our favorite Rahul Reddy garu. Hearty welcome Rahul garu.
Thanks for inviting, and it's always a pleasure to be answering the questions and listening to the issues that are there. It is an education session for me also most of the time to get feedback from the people. Let's go ahead.
Thank you so much. And you seem to be in a very different location, already in a holiday mood.
Yeah, I'm taking a vacation in Hot Springs in Arkansas. It's a nice place in a mountain location. I'm in the RV right now. Thanks for the technology. Thanks for all the computer programmers that have done these things possible, where people can sit in the jungle and then still communicate with the rest of the world. Technology is growing, I think so. And, thanks for all the H1B people who have done these kind of miracles. But for them, we wouldn't have been where we are right now.
Amazing, Andy. Amazing revolutions, amazing innovations that happened, and feel very proud for all the H1s that are part of this whole innovation, Andy. Thank you for the service that you're offering as well, and happy holidays to you.
Thanks.
So, Ivala topic, Andy, actually a very unfortunate thing that recently happened. That discrimination seems to have won as of now. So, just what are your thoughts on it?
It took a long time for the ladies to get the voting rights. It took a long time for the African Americans to get the voting rights. Even though after the Civil War, they did amended the Constitution to give the voting rights to the colored people. The states had many restrictions. They said some of the states put a restriction: your grandfather must not have been a slave. Some of them said you are not literate, you are not paying enough taxes. They put a lot of restrictions on African Americans, and finally in 1968, then they passed a bill in the Senate and the House that liberated all these restrictions and say any restriction will be a violation and they will be prosecuted. For the women's suffrage also, until 1920, women's were not been voted. I mean, it's only 100 years ago that still now. I mean, in 1920, December. So by this time, actually, it hasn't been 100 years that the women start getting the votes. Yes, there is discrimination. We had a Supreme Court that overturned the decision with regards to the gays and lesbians. Now, we still are discriminated. Immigrants are discriminated. They're discriminated based on the origin. Now, we do understand as an immigrants, we don't have equal rights to the Constitution as much as the U.S. citizens. That is understandable. But what is not understandable is that within the immigrants itself, why is there a discrimination? Why are we looking into where we are getting born? Why are we just not looking into the skills? Yes, there were restrictions previously on Chinese people when long time before African Americans, initially within Europe itself, there was discrimination against Italian immigrants. All those things were being taken off, but still we do have a very gross discrimination. The way there are two things under. One is immigration per se. That means we can see the immigration. The second is immigration effective, and when it becomes discrimination per se and discrimination effective. So when you apply the law, when you see the plain law, it doesn't look like it's a discrimination, but when you apply, it definitely is a discrimination. A lot of people have put a comment on our thing, hey, everybody is getting 7%. What is your problem? Well, here is the problem. What if it says that, all whites will get 30%, all African Americans will get 30%, all Asians will get 30%. No, there shouldn't be anything like that. I mean, everybody should be equally treated. Everybody should, we don't want Asians to be given 30% just because we belong to a race. We just should be treated equally. And this is what exactly we asked for the entire conversation. Good battle done by Jo Lofgren. She lost. I mean, we all lost along with her. We will have to try in the next Congress. This Congress is going to be over on January 2nd. There is no schedule of any meeting right now. There is some speculation that they may meet again in this week. The reason is that President Trump may not sign the COVID relief bill. And they may meet, but even if they meet, the chances for the 1044 to come in there is very rare. The poison pill that was done by Rick Scott, of a senator from Florida, has killed this bill, where he practically restricted the Chinese nationals out of this bill. And that's the reason why this is dead. So it may not. So we have to fight another day. I mean, we failed. We failed very good. I mean, let's try again when the new Congress comes in, starting from January 2nd. We should try to get this bill passed again in a different format, in a different way.
Yep. Let's not lose hope. And yeah, I think that's all we all have to be hopeful of, that let's not lose hope. There should be a brighter side at the end of the tunnel at some point. And as you rightly said, it took 100 years for getting a vote right and everything. I mean, it's been 100 years that women got a vote right. I think we all will be having and talking about it sometime as a history in future, but let's hope for the best.
Let's go to the questions, Sunday.
Yeah. Let's go to the questions here, Randy. We have the first participant. Let's take the question. Let's take the caller here. And before we take the caller's question, Randy, let's have the question from YouTube. It is from Ashok. And what he's saying is, on advanced payroll, how many months we can be out of job and how many days we can stay outside in the US, outside of US.
Let's go to the question, Sunday.
Yeah. Let's go to the questions here, Randy. We have the first participant.
I think so. The caller, if you can mute yourself, mute your video or TV, that will be very good.
Yep.
Thank you. We'll go to the caller. Just hold on for a minute. The advanced parole people should not try to stay for more than 2 or 3 months outside the country, though.
Okay.
Because there must be a continuation of the job in United States. If there is a failure of job in United States, though, it will create a problem for him. So if there's a discontinuation of the job, the 485 will be fallen apart. So if the person has any intention of staying more than 3 months outside the country, leaving the job here, he should consult a lawyer. I would recommend it should be less than 2 months. If it's more than 2 months, there may be discontinuation of job. Even if you're working outside the country, you're getting paid outside the country, with the same American company, though, you may have a problem saying that you may not have a job here. So that will create a problem. I would strongly recommend, if it's more than 2 months, you consult a lawyer. If it's within 2 months, I don't see much a problem. You can go for a 2 months period and stay there and come back. Assuming that your job is continuing, I don't see a problem.
Okay.
You want to go to the caller, Sita Garu?
Yep. Ashok Garu, that's your answer. And let's take the caller's question. And here, 7664, that is the caller. Please go ahead with your question.
Hi, Rahul Garu. I'm calling from California, and I have a question regarding my daughter's aging out. My priority date is March 2012, EB2, and in the month of October, I filed 485 after downgrading. So my daughter is going to age out on January 2022, and in the last week, we submitted her F1 visa for our bachelor's. And it's like its waiting time is 8 months, it seems. So by that time, she's planning to complete her bachelor's, and she's planning to enroll into master's, like BS, MS program. So the question is, do we need to file another F1 visa for master's, or is the same F1 visa?
Is it going to be the same university? Is it going to be a different university?
Same university, yeah.
If it's going to be same university, they can amend the I-20 and supplement it. And the USCIS will come to know about this I-20 though. If it's a different university, it's definitely complicates. If it's the same university, it doesn't complicate that much. You may also want to consider, now, I know the situations are different, our kids are different. You may also want to consider that if she takes a master's degree though, she will lose the 2-year, assuming that she's doing a STEM degree though, she may lose the 3-year OPT and STEM extension possibility for bachelor's degree if she directly goes to master's degree.
Okay, I see your point, Rahul Garu. Yeah, but it seems at least we need to be on 2 quarters to get a OPT option on a F1 visa, but that is not going to happen because she's going to complete on her...
Actually, they're a little bit liberal on that rule right now. She should be only in 1 quarter, but under your situation, it looks to be fine. Let her go to the master's degree, but I'm just pointing out, as long as you're aware of it, that's fine. If you amend the DSO should be able to amend the I-20 and she should be in a good shape.
Okay, and the recent changes Trump did is not going to affect our plans?
Which particular changes are we speaking about?
He like if any F1 changes or degree changes, he made some restrictions, right? We need to refile that.
Good point. As of now, those things are not effective. Thank you for raising. I forgot about it. Yeah, you're right. But as of now, those rules are not effective. I don't know if they're going to publish it though before he goes. But as of now, those rules are not active. So your daughter is in good shape right now.
Oh, thank you, Rahul. And last question, is there any chance in 2021 before October, my priority date may be current for a couple of months? And
you know the people who predict the priority date. You know that I'm the worst person to predict the priority date. I can't say anything more than that. So yeah, keep watching, but I'm a wrong predictor. So let's go to the next caller.
Thank you, Rahul Garu. Thanks for all your service. Thank you very much.
Yep. Thank you, Andy. Let's admit the next caller, the caller ending with 8219, Andy. Before the caller's question, Rahul Garu, there is a question from Murli Garu on YouTube. He's saying that please help us understand how the spillover from family-based visa is applied for employment-based. There seems to be no progress in EB2 and EB3, whereas EB1 has become current.
Yeah, the progress definitely seems to be a little bit slow. We are expecting that as we go on by the end of the year, we're expecting the final action date to be moving much faster for the EB2 and EB3 though. We are not expecting the filing dates to move. We have been predicting, we've been predicting final action dates is not going to move, and we have seen that. The filing dates actually in January has moved back, and they are actually USCIS is going with the final action date. But we're expecting by the end of this year, the final action dates to move. We're expecting them to move. End of the year, normally we may expect more progress from March onwards all the way to September. That's when we start seeing final action dates moving.
Okay. There is a few more months for it, Andy. Let's take the caller question here. Caller ending with 8219. Please go ahead with your question.
Hi, Sita Garu and Rahul Garu and Kumar, and thanks for taking the call and helping us. Actually, there was an incident happened for me in 2011. I got my H1B approval till 1/10/2011, and USCIS approved on 1/22/2011. So by the time I received my H1B and realized I went back to India, it's around April 4th, 2011. And I worked like unauthorizedly like 80 to 90 days. And I went back to India, applied for a new H1B and came back on August 2011. So my question is on I-485. So there is a question saying that have you ever worked in US without authorization? So I kept as no. Is it? Just want to check, is it right or wrong? Or
no, that's definitely a wrong thing that you did it. I would like you to do one thing, something called interfiling. You can always inform the officer saying that, look, there was an error that I did on the form. I actually worked unlawfully for a period of 89 days. You mentioned the circumstances on it. You can even supplement a form called I-485, the entire form again, and correct it and send the form. They will take it. And it's not a big deal. The reason is that in the employment-based, though, there is a rule that 245K section, which if you do an unlawful presence or unlawful work for a period of less than 180 days, it's not a bar for you to get a green card. Since it's 89 days, I'm not expecting much problem for you.
Okay, thank you. So in my situation, is it okay for me to convert to EAD or do I have to stay on H1?
I don't think so. Just because of this particular one reason that you are speaking about, I'm not worried for you at all. Okay. If there's any other reasons, I don't know. But for this particular reason, I'm not fearful. People who have gone under this situation, I've not seen a denial for them. I've not seen. Okay,
sure.
Thank you very much. Thank you, Kumar.
Thank you. Let's take the next caller, Andy, 5003. Before we admit the caller and take the question, I see another question, Andy, from Ashok Garu. What he's saying is on EAD, will there be any flexibility that someone can stay outside USA and come back before his or her date gets current?
If he's the main applicant, though, the job connection is very important. Ashok is trying to leave the job here in United States and wanting to go and work there in India. The whole reason why he's getting the green card is because he has a permanent job offer in United States and he wants to work in United States. His staying outside the country for a long period of time may indicate that either he doesn't want to stay in this country or there is no job offer for him here in the United States. So those are problematic things for him to stay. I would recommend, since we're predicting the priority dates movement very faster though, if he wants to plan to stay for a longer period of time, maybe wait until he gets a green card and then he can take a little bit longer trip. When I'm speaking a little bit longer trip, I mean to say maybe 4 or 5 months trip after he gets a green card. For now, he should not leave the employment. He should not stay outside the country for a longer period of time.
Awesome. That's your answer. Thank you so much, Anil. Let's take the caller question. Caller ending with 5003.
Hi, Rahul Garu. Can you hear me?
Yes, absolutely.
Hi, Andy. My priority date is September 2015. I moved to new employer B, in August. With employer A, I have my I-140 approved. So if I wanted to go back to employer A, when I spoke with employer A attorney, they told me that in case if my priority date becomes current for filing in October 2021, so they're asking me to apply for H1B transfer because currently I do have two H1Bs and 2 I-94. So they're saying that if I go back to my old employer,
So let me ask you.
Out of status.
So you have the H1B and I-140 with company A. You have a H1B with company B that didn't apply the I-140. When is the H1B with company A expiring?
It will expire in August 2023 with company A.
Did you ever travel outside the country after you got the H1B approval with company B? After you filed the H1B with company B?
No, sir.
Do you know if your company A might have withdrawn the H1B?
They did not withdraw. I spoke with my employer. He told me to, come back. But attorney is saying that.
I got the point. I just wanted to ask the question. Yeah, I don't see a reason why you have to file a H1B with the company A, because you told me that your H1B is expiring with company A until August of 2021. You don't need to file immediately. You need to file it sooner, but you don't have to file it immediately. Now, normally the companies would like to have a safety precaution for, if you tell the Labor Department, hey, give me the money for the 1 year period that you did not work, they're in trouble. So normally what we tell the employee is to write a clear letter to us that you worked with company B and you did not work with my company for a period of those 8 or 10 months. And then you got paid from that company from those period of time. So that will be a safety that if by any chance you come back and strike my client, then I can say, look, you gave a letter to me saying that you did not work for my company, so you're not entitled for the salary. So we take these kind of precautions, but is it necessary for company A to file a H1B again? I don't think so. The only thing is that, are you going to go back to the same client, or is it an client company A?
It is consulting company, and I will go back to same client.
I don't see a reason why you need to file the H1B. That's my opinion. But it's up to the company's lawyer how they interpret their thing. I don't see a reason why you have to.
Company lawyer is saying that since I do have 2 active I-94s, if I go back to company A,
no, that's not right.
It will be like out of status.
No, that's not considered out of status. Look at the I-94 number of both the company and company B. Guess what? The I-94 number is the same. It doesn't change. That's my opinion. That's up to him to have his opinion. That's all I can tell. Okay?
Thank you.
Okay. Thank you.
Thank you.
Thank you.
We have done this hundreds of times. We didn't have any problem.
But even if I apply for 485, it should be fine, right?
It should be fine. Absolutely no problem. A lot of people applied. Thousands of people applied like under your condition.
Got it. Thank you, Andy.
Thank you.
Thank you, Andy. Let's admit the next caller. The caller ending with 0813 here. Question from YouTube, Andy. Rahul, the question is from Kapil Sharma. What is his question is, can Trump still bring in DS elimination rule for F1 and H1 lottery replacement with wage order rule?
Yes, he can. Because the regulations were published, the proposed regulations were being published. And there was a comment period. The comment period was over. So before the Trump administration leaves, they can publish this one and make it final. And that's going to create a lot of problems for us. Yes, he can do it.
Okay. So let's take the caller's question. The caller's question, caller is from 0813. Please press *6 to unmute yourself, Andy. There could be some lag if you're listening to us on YouTube. Please ask your question here. I see the caller as 0813.
Yeah, can you hear me?
Yes.
Yeah, hi. Hello. The thing is, right, if 2 employers can file the AO adjustment of status if working on a concurrent filing of H1B?
Working on what concurrent H1? 2 companies file the adjustment of status at the same time?
Yeah, can we do that?
Under what circumstances? You have I-140 with both the companies?
No, actually, I asked the wrong question. So, if working for company A filed adjustment AOS, okay, and company B with whom concurrently working, can they file a labor certification firm application?
Yes, they can. Absolutely not a problem.
Okay. So there is no problem, right, with that?
No problem. If you are under, if company have filed an adjustment of status, and you're working with company B. Company B now wants to file a labor and I-140 application. Absolutely no problem. Yes. They can do so.
But if working for both companies at the same time also.
Oh, so you're
on a concurrent H1B.
You're working on concurrent H1B. Yeah, absolutely no problem. Very good.
That's right.
We like your taxes. Thank you.
Okay. Yeah, thank you.
Thank you. Thank you, Andy.
That's all my question.
Thank you.
Thank you. Bye.
Let's take the next caller, Rahul Garu. It is from 5855. That is a caller question. So before we take the caller, I have a question from YouTube, Andy. It is from... hi. Yep.
Hello.
Yeah, 5855. Go ahead, sir.
Hi.
Yes, sir. We can hear you.
Is it my turn?
Yes, your turn, sir.
You can hear me?
Yes, we can.
Okay, hi. Thank you for taking my call, Rahul sir. I have a question for you regarding a new H4 EAD application. I just filed this based on my wife's approved I-140 application, and it was filed in October. My first question is, how much processing time does it take for a fresh new H4 EAD application to get approved? And do I have any control if I can expedite this? Because it seems it was sent to California, which is the slowest processing center.
You don't have a
control.
So
what control do I have?
None. Zero. Zip. Right now, according to the processing times of the California, it's taking approximately 20 months for them to process it. There is no premium processing right now. If you want to join a court litigation, Reddy Neumann P.C. does file every other month. The court litigation you can join. But as such, you can request the ombudsman, which is not working. You can request a congressman, which is not working. You can go online and ask for the expedited, which is not working. Absolutely, everybody is trying this. This administration intentionally is trying to, practically they couldn't cancel the H4s. They're trying to delay it. Delaying justice is considered to be denying justice. That's the reason why we go to the court to get these things approved. But as such, the administration intentionally want to delay the application. That's the reason why everywhere, it's a lengthy period of time for you to get a EAD. And there is no premium processing. I hope the new administration, which is coming on January 10th, will pay attention to this H4 EAD. It's already been addressed. Letters have been written to the new administration that they should address this H4 EAD delay. Let's hope that they will take care of it. If not, I would recommend that you join the court litigation.
How do I join this court litigation, sir?
You can send an email to info@rdnlawgroup.com and we will send you the detail. You will not be one person. You'll be part of 100 people or probably sometimes even more will be part of the court litigation to request the USCIS to adjudicate your application. Unfortunately, there is no premium processing available.
I know the premium processing law was passed by Trump in October, but I guess it was not.
Right.
It was never activated.
It is not. It's not implemented yet.
Okay, and the court case that you're talking about, is it the same thing called the writ of mandamus? Is it the same thing?
You're absolutely right.
Okay, so if I join that will actually force them to make a judgment in my case within how many days?
You would, I wouldn't give all the details of the court litigation right now. In this one, we do conduct a separate conference call every week on it. I would want you to attend it. It will take a long time. It's not like, hey, you pay the money and the next day you will get an approval. It doesn't work that way in the court system. The judge has to rule in your favor to get it. We will discuss more thoroughly on that in a private conference call, okay?
Okay. Thank you so much.
Thank you very much.
Thank you. So I would advise people to reach out to Rahul Garu directly on the other call, Andy. Yeah. So we have the next caller 7479. Sir, could you please mute for a minute? We'll get back to you in a minute. The question, Rahul Garu, is from Murli. I think it is in continuation to his prior question on YouTube. What he was asking is, looks like his kid has another 18 more months before she ages out. So based on some immigration forums and all, the family-based spillover is applied to EB1 and then to EB2 and then to EB3. What are my chances? Are my chances better in EB2?
Not true. The family-based things are not applicable for EB1, and then leftovers will go to EB2. That's not true. They'll be allocated proportionately.
Okay.
Proportionately is, I think so, it comes around 28%, if I'm not mistaken, to the EB1, about 28% to EB2, and about 28% to EB3, and then the rest of it to the rest of the categories like EB4, EB5, and other things. It's not like all the unused family immigration will not go to EB1. It will be proportionately. Yeah, I would still be cautionate. I would not like the kid to get married to the adjustment of status application. I want the kid to have an alternative plan so that if this fails, because the parents will should still get the green card, but the kid may be thrown out. So at that point of time, you need to have a defensive action. They should plan for it. But yeah, his interpretation of law is what I'm debating, but he should be more precautious on, take caution on what his kid do before the kid gets married to the adjustment of status.
Okay. Thank you, Andy. Let's take the caller's question here, Andy. Caller ending with 7479. Please press *6 to unmute yourself, and you can go ahead with the question.
Yeah, hello, ma'am. Thank you, and Rahul sir, thank you so much for for your time. So my question is, if I move to a company B after 180 days of filing 485, at the time of GC interview, if I don't have a real client project, but I have a paycheck and W-2s, will that cause any issue?
We haven't noticed that causing any problem because it is the employer that should count, not the client that should be the matter. As long as you're getting paid, sometimes you may even directly work for your employer too remotely. So nothing wrong with it. Sometimes you may want to update what the company is doing, strategies to do the things within your own particular field of endeavors that you are there in the labor certification. That should not, as such, cause any problem, though.
Yeah, thank you, sir. If I move to a company B after, if I get laid off after 150 days, not after 180 days, is the law actually waiting, pending 6 months, 180 days after filing 485, or actually working for the company A for 180 days?
It is working for the company A for 180 days. If you lose the job for within 180 days, your 485 is in trouble. Now, when you look into the law of the I-140 validity of the priority date, the law is completely different. There, what it says is that the company must not have withdrawn the I-140 within 180 days after it's been approved. When it's come to the 485, you must be working for the same company for at least 180 days before you can port to a different company. The law is very strict on this one.
Okay, sir. Because my impression was, it's 180 days of pending. So that's what, I got.
You must work for the company for 180 days.
So if I get terminated, then it's a problem.
Definitely. That's going to be a problem.
Yeah. Thank you, sir. Thank you for your time.
Thank you.
Thank you
very much.
Thank you so much. Let's admit the next caller here, Andy. The caller ending with 1616. Rahul Garu, YouTube question seems to be very similar to what the caller just asked. Maybe it could be the same person, but I'll just read it out. Here it's from Raj. Sir, can you just go on mute for a minute? We'll get back to you after the YouTube question. The question is from Raj. What he's saying is he's an EB2, priority date is January 2011 with an I-140 approved. How long can I stay in the US unemployed while I have an I-485 pending greater than 180 days after receipt date? Without employment, am I risking a green card?
Without employment, you are risking the green card. There is no grace period available like the way we have in the H-1B for a 60-day period that we normally have. So he will definitely be risking if he doesn't have the employment. Now, if the gap is there for 3 days, 4 days, 1 week, will that cause any problem? Now, it's not there in the law, that most probably they may be fine, but I would definitely discuss with the lawyer on that. Long periods of unemployment is definitely not allowed on the 485. If you are the main applicant, though. If you are the dependent, there is no rule. You can be unemployed. If you are the main applicant, you cannot be unemployed.
Okay, so that's your answer. Yeah, let's take the caller's question, Andy. Yeah, caller ending with 1616, please go ahead with your question. And thanks for waiting.
Hi.
Yes,
hi, sir. I've applied. Can you hear me?
Yes, absolutely.
Hello?
Yes, we can hear you.
So I have a quick question. Quick question regarding, I've done EB2 to EB3 porting in October. Okay. And so if at all I want to change a company, so I understand that I have to stay with the company for 180 days after filing. I just got the receipt like last week. Okay. So if at all I intend to change a company in the future, what are the implications after 6 months? Say, for example, I go from this company to another company. All I have to do is file 485J and get, just in case I don't want to use H1 and use the EAD and AP. So I'll be married to EB3 and just stay with them forever. And then at later point, if I want to jump to company C, how does it work?
First, can you tell the audiences, when did you get a receipt notice? When was your 485 application filed, received date by USCIS?
I got it on October, I filed on October 19th, and actually I got it yesterday in my post, which is like 26th December.
Okay, before I go to the answers, I want to point out to everybody that this is a timeline that it is taking to get the receipt notice. He is saying that in October 19th, the USCIS received, and about 4 days ago, he received the receipt notice. So approximately it's taking about 8 to 10 weeks. So please don't bug your lawyers that why have I not received the receipt notice? This is a common story. Now, coming to you though, it's a little bit different rule for you though. The 180 days is strictly applicable for everybody, including you, but I also want to make sure that your I-140 has been approved, because it will take about, let's say, for example, October 19th is, and you count 6 months from there, November, December, January, February, March, April. By April, you can move to a different company. But what if the company withdraws the I-140? Your downgrade I-140 will still be pending by that time, is right? Assuming that you don't convert it to premium processing. Okay?
Yeah,
so
say
it is
say if I do premium.
Yeah, let's say you do premium though. Technical rules tells that you should only wait 180 days from the time you file the adjustment of status. Okay? Technical rules tell that. However, though, I may have a problem. Remember, I was explaining another guy that the priority date you can port if the I-140 has not been withdrawn within 180 days after it's been approved. I don't know if for any chance the company withdraws the I-140, okay? Will they implement the law differently? It may cause some confusion with the officers because they may not understand the law very clearly, and it may cause great problems for you. I would recommend this for you.
Yeah, I understand all of that. Yeah, so do premium and wait for 6 months is the minimum time. So my question is, after that, what happens?
After the I-140 is approved, yes, you can move to company B. You can move to company B by filing a 485J supplement. From company B to company C, there is no 180-day rule. It's only the company A to company B 180 days rule. After you join company B, you can switch any number of companies for any number of time until you get the green card. But every company needs to file a 485J supplement.
Just the 485J supplement or labor and 140 and the whole thing again?
No need to file a labor and I-140. Absolutely not required. That'll be waste of money. Just 485J supplement, and there is no filing fees for it. At least under the current law, there is no filing fees for it.
Okay. One last question, sir. So whole process is fine. When will I know? Say once it moves to the table 1, which is the final action date, right? The final action date, what happens? I mean, my application will be processed, or how will I be notified? What will happen?
Well, it will continue staying there with the USCIS. A lot of times it keeps on transferring to one service center to another service center. Nothing will happen until the final action date becomes current. But in between, sometimes they do issue an RFE asking you to recertify whether you're working with the same company, and they want to have the 485J supplement. Most of the time they issue an RFE for medicals and 485J supplement, or sometimes they don't issue until the final action date becomes current. Nothing will happen. You'll keep on getting the EAD and Advanced Parole extension. Once the final action date becomes current, the USCIS may send an RFP to have you file a 485J supplement and the medical, because medical expires in 2 years. Or you can submit a 485J supplement without them asking. That's another way of doing the trick. And if the USCIS does not issue an RFE and does not act on it, I will raise a service request. On the day one when your final action date becomes current, I will raise a service request. Look, I've crossed the processing time of the 485. Please adjudicate my application. You can raise a service request and they will issue an RFE at that time.
Okay. And then what happens? Just they process it and finalize it?
Then they will request, right now, they will request you to come for an interview, you and your family, and you will have to attend an interview. There is a chance they may waive an interview. But once you go to the interview, then they will approve the green card at that time.
Okay. Thank you, sir. Thank you so much.
Thank you very much. There is a chance the new administration might take a different route of waiving the interview, which used to be there before 2017, but now they're interviewing at least 98% of the time. Thank you very much, sir.
Thank you, Andy. Thank you, Rahul Garu. Let's take a very short break and be right back, Andy.
Sure.
Please stay tuned in.
I fear becoming a second-class citizen.
I fear being attacked for my faith.
I fear for my child's future.
I fear being in debt all my life.
I fear losing my job and my health care.
I fear science and facts will have no place here.
I dream of respect for all.
I dream of combating COVID-19 and climate change.
I dream of restoring America's promise.
I dream the American dream.
Vote for the country of our dreams. Vote Ossoff and Warnock. TSP Victory is responsible for the contents of this ad.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్, 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్.
Where have you been?
I went to vote.
Why bother? One vote doesn't make any difference.
Of course it does. Desi vote just turned Georgia blue.
Yeah, but I don't do politics.
But politics is being done to you. Make your voice heard against openly racist and corrupt people. It's about our children and grandchildren.
You're right. May I ask, who did you vote for?
Democrats, Ossoff and Warnock, of course.
Grandma knows best. TSP Victory is responsible for the contents of this ad.
fear becoming a second-class citizen.
I fear being attacked for my faith.
I fear for my child's future.
I fear being in debt all my life.
I fear losing my job and my health care.
I fear science and facts will have no place here.
I dream of respect for all.
I dream of combating COVID-19 and climate change.
I dream of restoring America's promise.
I dream the American dream.
Vote for the country of our dreams. Vote Ossoff and Warnock. TSP Victory is responsible for the contents of this ad.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
Oh. We are back after the break and thanks for tuning in. So we'll get back into our questions. Rahul Garu, we have a caller, Andy. It's caller ending with 9744. Let's take the caller's question. Go ahead, ma'am.
Hello, Rahul Garu. So I have a question, Andy. So our priority date is in November, November 2014. So we have applied for I-1485 and EAD and AP in October. So we have filed on October 30th. We haven't got any receipt. And according to the December bulletin, the dates moved back to Jan 2014. So what is the impact? We already filed. So
you come under October. You don't come under the December law. You don't come under the January law. Your application was being received by the USCIS on October 30th. So was the priority date, filing date current at that point of time? The answer is yes. So you're good. Yes, you may not have received the receipt notice by this time. And that's common. That's the reason I made sure that the previous caller who said he received the receipt notice 2 days ago, I asked him, when did USCIS receive the application? He said that it is October 19th. If I tell it, people are like, maybe, but here's the thing. So it will take a little bit longer time for you to get receipt notice, but you'll be fine. You are in there. Your foot is in there right now.
Okay, Andy. So for any reason, I have been hearing like some of the applications are getting denied. So for any reason, if our application gets denied, so what can we reapply?
There are a couple of stray instances where they are illegally denying the things. You can always say, our office is intending to file a lawsuit, clubbing up all these people together, and then filing with the USCI, filing in a court saying that, hey, why did not you reject in a week? Why did you reject after 2 months? We didn't know why you took all those things. So we are intending to file lawsuits against the USCIS on that. And there are other law firms that are willing to do too. If by any chance they reject it, we can always refile it, and they refile it, doesn't work, then you have to go to the court system.
Okay, but even if our priority date is not current, like we can refile.
That's the reason why if it's done by mistake of the USCIS, you definitely can refile it, pointing out to that. If by any chance, if there is an, marginal error, it could be yours, it could be there, then court system is the best thing to approach at that time.
Okay, Andy. Thanks so much.
Thank you very much.
Clarification. Thank you, Andy.
Thank you, Andy. And you can watch TVASIA on Dish, Sling, and WorldBBTV. Thank you for your continued support. Let's take the next caller, Andy. It's 7153. Rahul Garu, before that, I will have the YouTube question, Andy. It is from Rita D. Her question is, hello Rahul Ji, after 180 days of 485, if I move to a consulting company and submit a supplement J during a green card interview, what happens if I don't have the actual client project but have HR?
I think so. We took the phone call of the same person was, same question.
Okay. So we can take the caller's question. Please press *6 to unmute yourself and go ahead with the question, Andy. Caller ending with 7153. In the meantime, I think probably we can take the question of YouTube as well. It is from Vinod Kumar. His question is, if the secondary of I-485 EAD uses it for getting a job or travel. Sir, just in a minute, we'll be back. We're taking a YouTube question here.
Yeah, secondary person takes the advanced parole or EAD.
uses it for getting a job or travel, is it considered marrying to the EAD application?
That the dependent will be considered to be married to the applicant. The main applicant will not be considered to be married to the applicant. Okay. However, it will be very surprising that you are willing to get a green card without your spouse. Mm-hmm. So practically when one person gets married, the whole team gets married. Okay. When the main person gets married, automatically the dependent gets married. That's for sure. Okay. But when the dependent gets married, the main person does not get married. But what are the chances that you want to get a green card without your spouse? So you need to consider that if your spouse uses practically, you are also you're also married. That's 99% of the time. Yeah.
Okay. So that's your answer, Vinod Garu. Go ahead, Andy. Thanks for waiting. Caller ending with 7153. Please go ahead with your question.
Okay. Thank you for taking my call. Good evening, Rahul and Shita Garu. My priority date is June 2010 with EB2 category. We filed at AOS in October, but no downgrade involved. In 485J, my attorney used my job title from PERM to avoid any risk or any future RFEs. But as per the PERM is a developer, but as per the my current job is a senior manager. Would that be an issue in future green card interviews?
I cannot go into the details of it. But one thing I can tell you is that you have a good lawyer, trust him. I have no reason to think otherwise.
Okay. Yeah,
he did a good job. Because what they are asking in the 485J supplement is that, is the job offer still there for you? The job offer is still there. When you give the title of senior manager, what do you mean senior manager? Are you senior manager of a restaurant? Or because it doesn't give a specific title. So your lawyer did a very, 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 very good job.
Oh, okay. Thanks. Because my recent H1B says that as a current job types, that's what I'm worried about. Like when I go with the pay stubs and
I got your point. I noted your point, but I still like your lawyer, the best guy you have.
Okay. Yeah, just another quick question in general, Rahul Garu. Why the Trump administration stopped releasing the I-485 inventory? So I used to that in I-485 inventory, right, and based on that, will there be any request from any ILA or your attorney groups to the new administration to, continue 485?
We should. Inventory? We will. We would like to get the inventory system like what it was before. Well, we need open information sources. What is going on there? If they don't release it, we can file a freedom of information, publish it ourselves, though. That could be one of the consideration. Yes, this new administration should, and I'm expecting should be able to publish those things. But let's see how this new administration will work as we get into January 20th.
Yeah.
Thank you very much. Thank you. Thank you.
Thank you so much, Andy. Rahul Garu, let's take the next caller. It is 6990. Before the caller's question, it's a question from YouTube, Andy. It's from Deepthi. Question is the derivative application for 486.
Excuse me.
Yeah.
Sorry, go ahead.
On for I-486 filed on October 21st got rejected. Per rejection notice, it says from I-944 or I-864 is required in spite of us sending 944 application. Is this an erroneous rejection? Can we appeal the case? And also, I think she says her attorney says these erroneous rejections by USCIS are common and they can refile it. Does it make sense to you?
It makes sense to me. There's nothing wrong with the lawyer. Absolutely nothing wrong with the lawyer. It's absolutely wrong with the USCIS. Have we seen this before? Yes, we have seen. It's a new officers. They don't know what they're doing. Sometimes they just reject the cases. It's a wrong rejection. It should be accepted by the USCIS. You don't need an I-864 to file a dependent 485 application along with the employment-based 485 application. Yes, you need that for filing for the family-based, not for the employment-based. Absolutely not needed. Your lawyer is right. USCIS is wrong. You should resend the application. They should be able to accept it. And if they don't, they can go to your lawyer, can go to the court system to get it, or you can contact us to do it. Okay. Nothing wrong with the lawyer.
Okay, awesome. Thank you, Andy. I think, that's your there's some good news there. Let's take the caller question, Rahul Garu. It is from 6990. Please go to the question, Andy.
Yeah, hello, Rahul Garu. Namaste, Andy. So I have a few questions here, Andy. So first thing, Andy, revocation time, so will it start from based on the firm or applied or approval date, or only after I-140 approval date?
What revocation are we speaking about?
So I'm talking about, let's say, for example, if I move to from company A to B, and we'll have some 6 months notice period, right? So what if if I'm not completing like? Sorry,
okay, so you're speaking about the I-140 validity, the priority date validities, right?
Right, right.
Okay. It is 180 days after the I-140 is approved, not when the perm is filed, not when the I-140 has been filed. It is from the time the I-140 has been approved. The company should not withdraw it within 180 days.
I see. Okay. Yeah. Got it. Thanks. So one more addition to it. So right now my employer said, previously my employer was revoked it, and my current employer says that we can still fight with the USCIS to get back my previous priority date. So what are the chances are getting in my favor?
Do you know when your previous company has withdrawn the I-140?
Yes, it was withdrawn.
Do you know when? Do you know when?
Hello?
Do you know when it was withdrawn?
It was, it was withdrawn on September 2000, last year.
How far after your I-140 is approved?
It's close to 1 year, Andy, for now.
No, you didn't answer my question. Since the time your I-140 is approved, when did your company withdraw the I-140?
Okay, so it is within less than 6 months. So I would say like in 5 months, they have withdrawn that.
Yikes. I would still want you to get an assurance when it's been withdrawn. I want you to file a FOI, Freedom of Information USCIS. You can do it online. It's free. It takes 10 minutes to do it. Try to get an online application on that. You will get it. If your company wants to mention that it's been withdrawn, and then they can file it, they can try your luck. There's a good chance that they may lose it, but no harm in trying it, I guess.
Okay. Yeah, thanks. Yeah, so in addition to that, me last time FOI raise chesanu, so I just got recently. So I don't see anything specific saying that hey, this
on
is
the
I-140
on the I-140 first page at the bottom right hand corner, it will tell that it's been revoked or withdrawn. It'll give a date on it.
Okay.
If you're not in front of it, you can come to the next. You can consult with a lawyer on that by sending a copy of the I-140 petition to him. He will be able to identify when it's been withdrawn. It clearly tells when it's been withdrawn. Okay?
Okay. Yeah, I don't see a specific reason. That's the reason I just want to check with you.
They don't need reason.
I'll talk to my lawyer.
No reason will be there. It will be there on the I-140 when it's been revoked.
Okay.
Thank you, Andy.
Okay, Rahul. Thank you so much.
Thank you.
Thank you, Rahul Garu. Let's take the next caller, Andy. 7801, that is the caller. And before the caller's question, I have a question from YouTube here, Andy. It's from Bhanu Maya. Is there any way we can bring parents to stay to USA to stay with us longer than 6 months B visa limit? I have an I-140 approved with the priority date of May 2015. I'm considering moving back to India as green card is not in sight.
Well, moving back to India, we are not the proper persons because you're an Indian citizen, you can. As far as your parents moving here with you for more than 6 months, no. There is no legal provisions that allows your parents to stay here permanently with you. No, nothing is there.
Okay.
No law exists.
Okay, that's good.
And nothing is in the proposal either.
Okay, Cool. The caller is from 7801. Please press *6 to unmute yourself and go ahead with the question, Andy. If you're watching us on YouTube, there could be some lag. Please press *6. Yeah.
Hello? Yeah. Hello, can you hear me?
Yes, sir.
Yes, we can.
Yeah, thank you for taking my call, Rahul. Like, my question is like, employer A to B ne change ayana. So, AOS file is October. So, considering if I'm married to AOS and EB2.
Wait. Did you file with company? You said you moved from company A to company B. Which company did you filed AOS with? Company A or company B?
Company B.
Okay, keep going.
Yeah, so నేను ఇప్పుడు AOS ఒకవేళ ఏడి వచ్చి నేను మ్యారేజ్ అయితే లైక్ AOS వాడుకుంటే down the lane if EB3 dates are faster, can I file a new AOS with company A and take that EAD and go there?
So right now you are on EB2 right now, is it right?
Yeah.
Yeah, once you get married to the adjustment of status though, if the priority dates of EB3 or the other priority date moves faster, it's not that easy for you once you get married to it.
నా ఎంప్లాయిడ్ ఏ దగ్గర EB3 లో ఉందండి. So is that easy thing to switch back?
No, it's once you get married to the adjustment of status, it's not going to be easy to switch though.
Oh, okay. And
let me tell you one thing, switching from one to another category is not that easy. There's something called caboose. You go to the end of the line. And I would recommend people though, once you are in adjustment of status, though, just stick along, wait for your time. You keep switching though. Once adjustment of status is filed, the USCIS gets so confused with the whole thing and then it gets blocked out there. Sometimes I remember it took like 6 years to clear the whole thing out. I would recommend people to just stay around, get your I-140 approved, stick around. It's just LA traffic. I mean, you go, there are like 8 lanes there. The lane that you're going, it doesn't move at all. And then guess what? As soon as you move to the next lane, the lane you are in moves and the lane you move doesn't move. And the problem here is it's not easy to change the lanes. Every time you change the lane, you go to the back of the line. That's another problem that you have. Remember that the processing time for 485 according to online says it's 36 months. So every time you file a new 485 application, that you go in the back of a line. I do not recommend to keep switching back and forth. Maybe
sure.
I also recommend people to, I know I told people not to get married. There are certain conditions, especially if your I-140 is not approved. Don't get married if your kid is about to become 21. I mean, kid is above 14 or 15 years old. Don't get married. But if I were in another situation other than these two situations, though, I would like to get married to the adjustment of status. I want to be free bird. And having married to adjustment of status, really, it's like, marrying a lady who's making tons of money.
Sure. And ఇంకొక follow-up question అండి, like ఇప్పుడు నేను ఏడి యూస్ చేసుకున్నాక, like can I work for other company without filing a 485J? Like current employer and
parallel, you mean to say parallel employment with another company? Yes, you can. There are some limitations to it. Yes, you can.
Okay, so I don't need to file a 485J.
No, if you're working with the same company and then you are moonlighting with another company, you don't need to file a 485J supplement.
Sure. Thank you. That's all.
Thank you very much.
Thank you so much. Let's take the next caller question, Rahul Garu. It is caller ending with 6648. And then I have a YouTube question here as well, Andy. It is from Anand. What he's saying is my H4I-94 expired and I filed 539 after 1 month of expiry due to COVID. My friends are saying it may reject. My lawyer suggests we can file. I do not know if these wordings are right. And it is NUNC.
Non-protunct.
Okay. NUNC pro TUNC rejected.
Non-protunct. Yeah.
Okay.
I would recommend this guy to leave the country. The reason is that once he files the I-539 after the I-94 expires, he is counting his unlawful presence. If his unlawful counts more than 180 days, there is a 3-year bar. And if it goes to 365 days, there is a 10-year bar. And we don't know whether they're going to take the non-proton argument and approve it or not. 1 year down the line, if they don't approve it, you're barred for 10 years. I don't want to take the chance. I want to leave the country right now to avoid all these problems. I don't want any determination to be made. I recommend this guy to leave the country as soon as possible.
Okay. Looks like there is a, like what in continuation to it, he just says like it's okay as per COVID, as per his attorney. Is there any suggestion? But I think you made it very clear.
Yeah, no, even if the COVID, I don't want to take my client's chances, risk here to getting barred for a period of 10 years. I would leave the COVID situation to the doctors, having been myself a COVID patient. I know the sufferings that people go through, and, vaccines are out right now. So I don't know. I'll leave that to the medical thing. But as an immigration lawyer, I tell this guy to leave the country as soon as possible.
That's great advice. Yes, and we have the caller 6648. Please go ahead with your question, and thanks for waiting.
Yeah. Hi, good evening, both of you. Yeah. Hi, sir. This is Sudhakar Reddy, and basically I filed my I-140 with company A, but after 180 days of approval, the company filed for bankruptcy, Chapter 11 bankruptcy, and USCIS revoked my I-140. Then my company B filed for my perm and I-140. It was approved, but with the priority date with the 2019. And when I talked with my immigration lawyer, they told that means that they contacted to USCIS and US sent one document which is related to the.
So what you're telling is that the priority date has not been ported.
Yes, sir. That was not carried.
Yeah, there are some exceptions to the 180-day rule. If the I-140 has been revoked for any fraudulent purposes, the I-140 will not be, the priority date will not be carried. There is also another exception that if there was some issue about the ability to pay and the USCIS revoked it, it goes back to the day of the approval though. That's why you will not be able to put the date. Since you said it's a Chapter 11 though, there is a good chance that the USCIS has revoked it because of the ability to pay issue though. Had the company withdrawn the I-140 though, before the USCIS has revoked it, you had a good chance of getting the priority date ported. But since they went and they said that based on the financial information, we found that your I-140 should not be approved. They might have sent an intent to revoke and then revoke the I-140. At that point of time, even though your I-140 has been revoked after 180 days, you cannot port the date.
Yes, sir. Then they send one document which was related like a policy matter document of VSG Inc.
That's exactly what I was speaking
about. Okay. Then is there any chance to reopen this to consider it?
No, I don't think so. You have a chance. Now, since they have already determined that the I-140 was wrongly approved, put it to the rest right now. Just stick with that 2019 right now, okay?
Yes, sir. Okay, sir. Thank you, sir.
Thank you very much.
Thank you, Rahul. Let's take the next caller here, Andy. And before that, we have a question from YouTube. It is from 𝗟𝗩𝗘 𝗪𝗪. His question is, I have PhD from India and I'm meeting all the requirements for EB1. EB1B. Can I apply for a green card and via EB1 even if I have not done PhD from US?
He said he's meeting all the requirements for the EB1B. First thing is that for EB1B cannot be filed by the applicants. It has to be filed by the employer only. Second thing, the second question he asked was, first question he never asked, but I'm answering. The second thing is that, does the PhD has to be only in USA? No. A PhD in India also works equivalently. From an accredited university, it works equivalently. It doesn't have to be from USA.
Okay. So probably he'll need to have an employer to file for his EB1B.
Absolutely, yeah.
Okay. Thank you, Andy. We have the caller caller here, the caller ending with 8626. Please go ahead with your question. I see you're already on mute, but probably you're on mute on your phone. Before caller question తీసుకునే లోపల ఇంకో question తీసుకుందాం రాహుల్ గారు. ఇక్కడ it's from Sridhar. His question is, can a 12th grade dependent kid with green card EAD continue his college education and also work in the US after his completion of graduation?
Assuming that he meets the requirement of the final action dates, where, because I don't want kids to get married. If you guys don't know what the definition of marriage, I want you to go to the October TVASIA show that we did in October, when it is considered to be married to the adjustment of status, because we don't want kids who are about to become 21 to be married to the adjustment of status. The reason is that once they get married to the adjustment of status, then they would not be able to get the green card, because if they get kicked out because of the age out restrictions. Assuming that the final action date becomes current, though, yeah, I mean the H4 EAD kid can work on an adjustment of status. I'm sorry, the H4 kid can work on EAD that comes through the adjustment of status. Absolutely not a problem.
Okay, thank you so much, Andy. We have the last caller here, Rahul Garu. It is with caller ending with 8727.
Hello.
Yes, sir.
Yes, sir.
Hello.
Yes,
Hi, Namaskar, Rahul ji. I have a question. Actually, I have recently applied for EB3 downgrade, and my priority date is October 2011. My question is, my son recently turned 18, and I am along with my application, I applied for EAD as well.
Of course.
So once we received the EAD card, he used that card. And in case after 21 years, the final action date does not become current. Yeah, does not become current.
I do not want this kid to use the EAD until the final action date becomes current. Do you understand Hindi?
Oh, okay.
Or which language you understand?
Yes. Yeah, I can understand Hindi.
So Hindi. So this is the issue. If he uses the EAD, he cannot move to the F1. And if the final action date does not become current, he will be kicked out the adjustment of status. He cannot move to the F1. We call in Hindi, na garka, na gatka. Your son will be na garka, na gatka. You don't want that to happen. So I don't want this kid to use the EAD or advanced parole until the final action date becomes current. Now, once the final action date becomes current, okay? Once the final action date becomes current, I'm fine with him getting married to the adjustment of status.
Okay. And thank you, Rahulji. Another question is when I can move to, once I receive the EAD, when exactly I can move to a new company? So is it a date I need to consider?
First, it is one is the I-140 must have been approved for more than 180 days. Okay. That's another rule. And 485 must have been filed for more than 180 days. These are the two rules because you file for the downgrade. And you can then move to a different company. However, though, one thing that I'll tell you again is that you file the 485J supplement, but don't use the EAD. Continue working on the H1B. When you move to a different company, file the 485J supplement, but also file the H1B. Because if you use the EAD and AP, guess what happened here? Your 18-year-old kid is married to the adjustment of status. And if the final action date does not become current, because once you use the EAD, you are out of H1B. You lose the H1B, your kid loses the H4. Your kid loses the H4, then the same thing. Na garka, na gatka will become. So be careful on that.
Okay. Thank you, sir. Thanks a lot for your response. Thank you, sir.
Thank you, sir.
Have a nice day.
Thank you.
Bye.
Thank you so much, Rahul Garu. It's been such a fruitful show with so many questions answered both on YouTube and from the callers. I think that was the last caller also we had for today.
Thank you very much, Sita Garu.
Thank you so much. So have a wonderful holidays, Andy. So this is for the viewers. That was this is our talk show with the experts on immigration. Please reach out to Rahul Garu at his office, Reddy Neumann Law Firm, for any of your immigration related queries. And wishing all the TV Asia viewers a very happy and a prosperous new year. Thank you so much.
I fear becoming a second-class citizen.
I fear being attacked for my faith.
I fear for my child's future.
I fear being in debt all my life.
I fear losing my job and my health care.
I fear science and facts will have no place here.
I dream of respect for all.
I dream of combating COVID-19 and climate change.
I dream of restoring America's promise.
I dream the American dream.
Vote for the country of our dreams. Vote Ossoff and Warnock. TSP Victory is responsible for the contents of this ad.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్, 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్.
Where have you been?
I went to vote.
Why bother? One vote doesn't make any difference.
Of course it does. Desi vote just done Georgia blue.
Yeah, but I don't do politics.
But politics is being done to you. Make your voice heard against openly racist and corrupt people. It's about our children and grandchildren.
You're right. May I ask who did you vote for?
Democrats, Ossoff and Warnock, of course.
Grandma knows best. TSP Victory is responsible for the contents of this ad.
I fear becoming a second-class citizen.
I fear being attacked for my faith.
I fear for my child's future.
I fear being in debt all my life.
I fear losing my job and my health care.
I fear science and facts will have no place here.
I dream of respect for all.
I dream of combating COVID-19 and climate change.
I dream of restoring America's promise.
I dream the American dream.
Vote for the country of our dreams. Vote Ossoff and Warnock. TSP Victory is responsible for the contents of this ad.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్, 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్.
Where have you been?
I went to vote.
Why bother? One vote doesn't make any difference.
Of course it does. Desi vote just done Georgia blue.
Yeah, but I don't do politics.
But politics is being done to you. Make your voice heard against openly racist and corrupt people. It's about our children and grandchildren.
You're right. May I ask who did you vote for?
Democrats, Ossoff and Warnock, of course.
Grandma knows best. TSP Victory is responsible for the contents of this ad.